Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And today we are going to do a final wrap of the Sheba Akula matter. And I've put this off for quite some time, but I do want to say one thing. Back in the early years of this blog, when I say early years, I'm talking about 2015, 2016, and even a little bit into 2017, I came this close to shutting the blog down. And the reason for that is simple. It's because I would do features and there would be practically no one, and when I say no one, I mean no one who looked at them. And it was very discouraging. Sometimes the hits didn't even make it to double digits. But I have a dear friend who told me way back then, because I confided in him that I was going to shut the blog down, and he said, Robert, don't be so focused on how many views you get. Trust me, some very important people look at your blog. And he turned out to be quite prophetic in that regard. And he convinced me to keep the blog alive. And if you'd have told me I'd have broken the Ronald Green story or other things that have happened with this blog way back in 2015, 2016, I'd have had difficulty believing it. I'm not naming the individual. Some of you may know who he is. But I'm very thankful that he convinced me not to pull the plug on the blog in those early days. And one of the points, the reason I said that is the Sheba Akula matter, on which we covered every day of the trial. We covered the final verdict of the jury, which was that he was guilty. That whole series of features didn't get a lot of hits. And I don't base whether or not I do a feature based on how many. That was an intriguing matter for me, but I am here to tell you that just as that gentleman told me 10 years ago, there was what I consider to be a very influential individual. His name is Jonathan Porter. He is a partner at the firm Hush Blackwell. That is a law firm. And many of you may recognize the Hush Blackwell name because that's the firm that LSU retained when they had to deal with the whole Les Miles situation. Well, not long back, Mr. Porter provided his intake in a 30-minute podcast on the Sheba Akula matter, and he said he was going by filings and media reports. Well, you're looking at the media reports because there was no other media coverage day in and day out of this trial. So it was heartwarming to know that even on this series of features, that somebody of note watched this, beyond just the immediate family members and others who may have worked at Dr. Akula's operations. So, like I said, he is a partner at Hush Blackwell. He is a former DOJ prosecutor, DOJ being short for Department of Justice. And I think his insights are tremendously beneficial. So we're going to merge various clips. We'll give you the link for the podcast. You can listen to it in its entirety. We're going to merge certain segments of it in with this feature. And let's begin right now and have Mr. Porter give you a quick 50-second overview of just the nature of the charges.
Yeah, absolutely. Thanks, Meg. Good to be back with you. So let me first give a caveat. I was not involved in this trial in any way. I'm working off of the publicly available docket plus media reports. So I'm doing my best here, but this is theories of wrongdoing. The main one that we should focus on is that Dr. Akula was essentially accused of having the hospice auto-enroll patients in GIP, or general inpatient care, people who just didn't need GIP for, at least according to the government.
All right, well, I think you would agree with me that Mr. Porter gave a very concise explanation of what Dr. Akula was charged with. And we're going to break away once again for about a little over 5 minutes, 5.5 minutes, and you're going to hear Mr. Porter discuss the Key Tam lawsuit. Now, he never identifies parties that are involved here, but as we covered that trial, you will remember it is Kelly Anderson who filed the Key Tam lawsuit. And I focus in on the hostess reaction when Mr. Porter informs her that the Key Tam lawsuit was filed 7 years ago, and yet she continued to work for Dr. Akula for 4 more years. You'll find an interesting reaction from the host. whose name is Meg, you'll find an interesting reaction. So let's break away for about 5.5 minutes and let you listen to that segment of the podcast. We'll be right back.
Vast majority of criminal cases are going to plead out, and even more than that on the False Claims Act side for a lot of reasons. Those are going to resolve. And a few years after that, one of his employees filed a key tam. So the way key tams work, Meg, and you know this, but some of our listeners may not, key tams are filed under seal in federal court. No one knows about the existence of that key tam except the court, the person who filed it, and the Justice Department. Now, the Justice Department then investigates for however long they want to investigate for, or however long the courts will let them investigate. And then they'll make a decision whether to take the case or not take the case. So in this particular case, the key tam was filed 7 years ago. And for 4 years, Dr. Akula had no idea that the key tam had been filed. For 4 years, the whistleblower continues to work for the hospice.
Wow.
In those 4 years, she took documents. FBI had her make recorded phone calls to Dr. Akula. And at one point, it appears she even, shook Dr. Akula down for some money. Just bizarre facts here. But the FBI investigation took a really long time, and Dr. Akula was actually finally indicted in 2021 for key tam. They want the government to take the case. Their cases are always going to be stronger when it's the government saying that person over there committed fraud, rather than if the government says, we really don't like this case, and it's a private attorney saying that there's fraud. It's always stronger when the government is making the argument that there's fraud. So they want to be 10 times out of 10, the whistleblower wants to be really cooperative with the government. If the government wants them to make recorded phone calls, they're going to make recorded phone calls. If the government wants them to go in and take documents, which is a different issue, and is a lot more complex. It's a longer conversation. Yeah. But, they're going to go do what the government tells them to do. They're going to go take the documents. They're going to make recorded phone calls. They're going to do whatever they can to make that case good, because they know at the end of this, if you settle for $1 million, you're going to get, 6 figures out of it for sure. And so they're wanting to be helpful. They're wanting the case to go well.
Wow, this is like a movie, Jonathan. I'm just thinking about.
We could turn this into a screenplay.
Yeah, exactly.
Reviewed by dozens of people. Yeah.
Yes. In my retirement, I'll start. All the crazy stories that went on. So, okay, obviously they're building a very, very strong case. And maybe one side note too, since this is a criminal case, and the whistleblower's interest is at least maybe partly money here. I mean, obviously he's going to jail, right? But is there money to collect here? Obviously we want bad actors out of the program, and now he's going to jail. Like, is it hard to recoup that? Because how much is the repayment back?
Yeah, that's actually. So I glanced right before we recorded this. I glanced at the docket, and there apparently the government and Dr. Akula are fighting over money.
Okay.
The government's worried that Dr. Akula is moving assets, which you're not supposed to do once you've been indicted. That's usually part of some standard conditions of release on bond, is that you tell the government before you're going to move funds around. And so the big question here is how much money is left. A lot of times in these cases, the lawyers get a decent chunk of change. Sometimes there's not a lot of money left over. That largely depends on what the defendant's financial situation is. But that's usually a factor, is there going to be money left over?
So the whistleblower, even if they could get 30%, there might not be 30% of zero is zero.
Yeah, so you can get a really nice judgment, I guess, that you'll never collect on. It'll be very impressive. You could get a big fake check to yourself, but you won't actually collect anything if there's no money left over.
Okay, so settlement, you're going to trial. So what do they have to prove at trial, since this is a criminal healthcare fraud case?
Yeah, so most of our cases, Meg, in the hospice industry are civil under the False Claims Act. Civil cases have a really low burden. It's what's called a preponderance of the evidence. It's essentially 50% plus one little bit, just a little bit more than 50%. The criminal burden is amazingly high. It's beyond a reasonable doubt. You have to show with a fraud count, you have to show intent to defraud, you have to show willfulness. Dr. Akula his jury was instructed that to convict him, they had to find beyond a reasonable doubt that he had like this bad purpose, this intent to actually cause harm to Medicare. And the big thing is a mere misunderstanding of, the technical points of a CPT code. It's really not enough to show bad intent.
All righty, folks. You've got a very detailed explanation there from Mr. Porter about the nature of qui tam lawsuits. And also at the end, he distinguished between a civil suit where preponderance of evidence that is all that is required versus a criminal trial, which is what this was, which requires proof beyond a reasonable doubt. But I want to focus in on that qui tam lawsuit because when we did the last Shiva Akula feature, we said that there was a distinct possibility that Kelly Anderson, who filed the qui tam lawsuit, all under seal with the government as the actual plaintiff, stood to come into a, quote, boatload of money. And that was the phrase used by defense attorney David DeVillers. He repeatedly used that phrase in opening arguments of the trial. And I know that Mr. Porter and the guest said that, well, usually you don't wind up collecting a dime because attorneys eat it all up and this, that, and the other, to where there's no money left. And I will tell you, I took some good-natured ribbing by the gentleman that I referred to at the beginning of this video about the qui tam lawsuit. And he said, Robert, you know she's not going to collect a dime. Well, I'm going to respectfully present to you that, yes, I do believe she's going to collect a dime. And unless somebody can convince me otherwise, I think she's going to get a boatload of money. And the reason that I'm saying that, and we're going to give you the federal judge's signed order where they have now seized, and I added the amounts up in about approximately 9 accounts, maybe more, but by my math, and I may be off a dime or two, but I tallied it up, and they have made an order to seize this money, and they now have seized it, and Dr. Akula is literally destitute. He has been declared a pauper. But here's the sum that I came to: $3,754,173.60. Now, when I did the feature several months ago about just how much Ms. Anderson may come into on the qui tam lawsuit, because it can be up to 30%, I did stress that without seeing the lawsuit, and it's filed under seal, there's no way to know exactly how much she may come into. But I had speculated a little bit that it could be, $900,000. Last time I checked, and I am a CPA, 30% of we'll round it to $3.8 million is around $1.2 million. So, and we don't know whether the prosecution may net the cost that they incurred to prosecute Dr. Akula. But I think, and especially unless somebody can show me evidence to the contrary, I think Ms. Anderson is probably going to do exactly what David DeVillers emphasized in the opening arguments when he was defending Dr. Akula, and I believe she's going to come in to a boatload of money. All right, let's break away to another segment of that podcast by Mr. Porter of Hush Blackwell. And I want you to see in this next segment just what he says about the government's evidence in the case. So it'll be, I don't know, about a 8-minute breakaway. No, I'm sorry, it's not that long. But anyway, we're going to break away, and that'll be the last segment from Mr. Porter, and then I'm going to come back and give kind of some post-mortem about the entire trial, lessons that can be learned from it and whatnot. So let's break away and let's get Mr. Porter's concluding remarks, at least from that I'm going to put in this blog, from that podcast. We'll be right back.
clearing that really high bar at trial was mainly through witnesses. So they had a bunch of Dr. Akula's former employees testify against him. One witness was a medical director who testified that he had charted that patients were stable, but then someone else went in and changed the charts to distressed. And I guess that was to support inpatient services. So that was if you're a hospice listening, don't go in and change your medical director's charts to support fraud. Another witness was a former employee who testified that she told Dr. Akula directly that they were treating patients who didn't qualify for hospice. You had the whistleblower herself, the one who filed the key tam, she testified against Dr. Akula. And then the hospice administrator testified and was probably one of the key witnesses against Dr. Akula. Apparently, what she pled to was that she changed patients' charts to qualify for them for GIP. And that's what she pled to. But, fascinatingly, she wasn't willing to testify that Dr. Akula instructed her to change charts. It was a really complicated story, it sounds like, not very clear, sort of like an indirect pressure thing. But, based on court filings and media reports, I'm actually a little underwhelmed with the government's evidence against Dr. Akula. The case appears to be that, one, Dr. Akula had direct control over billing. That's important. Two, the audit where the hospice 100% failed, that put Dr. Akula in notice that the billing was wrong. Three, Dr. Akula signed that standard Medicare enrollment paperwork that put him on notice that he's got it, which is, I think that's always a bit nuts.
Yeah.
And then four, that Dr. Akula, as the owner, was the one who financially benefited from submitting these improper claims instead of claims for respite care. That evidence is not all that strong as far as federal criminal cases go. Part of what the government needed to prove was intent to defraud. That's like a bad or evil mindset. I don't see evil in that evidence necessarily. A lot of that is like should have known evidence, which is not enough in a criminal trial. What's interesting is the government filed a pleading in December that addresses that intent to defraud problem. And their position is pretty unusual. The prosecutors say that the nature of the scheme is, quote, not a fraud that could have been committed accidentally or negligently, unquote. I'll be honest, I don't love that argument from the Justice Department. CPT codes are really hard, Meg, and people get CPT codes wrong all the time on accident or through negligence, sometimes intentionally. Intentionally is fraud, but accidental or negligent doesn't mean fraud. So to me, that's just a bad argument by the Justice Department. In addition to the CPT codes can't be accidental or negligent argument, the prosecutors pointed to witness testimony that billing for inpatient care is unusual in hospice. But that doesn't remotely say that Dr. Akula, knew that it was wrong. That just means that it's like objectively wrong for people in the industry if you had that knowledge. So the evidence, at least from my limited vantage point, doesn't appear to be all that strong relative to what I'm used to seeing in criminal healthcare fraud cases. But the jury still unanimously convicted Dr. Akula of healthcare fraud. It did so rather quickly. Under 2 hours of deliberation, which is quick. I'm not saying that it's the wrong decision, just that the evidence was not overwhelming to me.
All right, I would assume that you found Mr. Porter's statements to be quite revealing, especially the fact that he feels like the government's case is underwhelming. His word, not mine. And I would share those sentiments having sat through the trial. And in fact, in the text part of this feature, we're going to repeat what I had said after the fourth day of the trial, and that was that despite the government presenting a very meticulous case, they had simply failed to provide a direct evidence that Dr. Akula set out to knowingly commit fraud here. I felt like he was going to be acquitted, and that didn't happen. It doesn't matter what I think, it's what the jury thinks. But I would share Mr. Porter's sentiments, having observed the trial firsthand, that the evidence, in my opinion, was very underwhelming. Nevertheless, a man is now serving 20 years in federal prison and has been ordered to make $42 million restitution as a result of the government's efforts. Now, as we provided all of the testimony, I had said I may go back and elaborate on some of the final testimony, and I'm choosing to do this even though it's now been close to a year for the trial, because I think there's some lessons to be learned, and as part of the post-mortem for this trial, that's what I'm going to do. Dr. Akula attempted to have an expert witness, David DeVillers, who was his attorney, attempted to bring in an expert witness. He was a doctor in a small town in Ohio, which many of you will remember that DeVillers himself is from Columbus, Ohio. And he was put up on the stand and he was asked a few questions, and then Mr. DeVillers moved for the court to declare him an expert witness. And when he did that, Judge Afric indicated that he had a few questions before making the ruling, and the questions he asked were, have you ever testified as an expert witness on any other trial regarding Medicare coding? And he said, no, Your Honor, I have not. He said, have you ever written a paper that was published with regard to Medicare coding? No, Your Honor, I have not. Have you ever taught classes which involved Medicare coding? No, Your Honor, I have not. Are you a board-certified hospice doctor? No, Your Honor, I am not. And with that, Judge Afric denied the motion to have that doctor declared as an expert witness. I can tell you that infuriated David DeVillers. I mean, you could see the anger on his face, and he literally said, well, then, Your Honor, I have no further questions. And so he sits down. They then called in, the prosecution called in Miss Sue May. We talked extensively about her. I'm not going to rehash all that. As a rebuttal witness. Now, Miss May, you may recall, her mobility is limited, so this is taking some time to get her back up on the witness stand. Meanwhile, the doctor has hightailed it. And so during that interim part, Mr. DeVillers asked if they could approach. And so they did, and it was a rather protracted little powwow. My own speculation is that, and it is speculation, is that Mr. DeVillers told the judge that, look, it was completely inappropriate to have that screening process, for lack of a better word, of my witness conducted in front of the jury the way in which it was. So I am seeking to have him testify on areas of his medical expertise. And so, because otherwise, my thought is he probably would have made a motion for a mistrial. When the powwow was over, Judge Afric looked at the jury and he said, and I'm quoting near verbatim here, look, being a judge is not an easy job. Sometimes you have to make snap decisions, and with the benefit of added time, I am going to permit the doctor to be back on the witness stand for him to testify on his medical expertise knowledge with regard to some of these patients. So now they have to get Miss Sue May back away from the stand. They have to get on the phone and call the doctor, who fortunately was still within reasonable distance, to come back into the courtroom and put him back on the stand to resume some testimony about his area of medical expertise with regard to those patients. I have had a couple of attorneys to tell me that that alone is grounds for a mistrial, or certainly would be grounds for an appeal, but we'll that's way down the road. An appeal has been launched, but that's going to be a long, drawn-out process whose fate is unknown. But I want to address that to a broader issue, because Mr. DeVillers has come under some criticism that, quite frankly, I don't think is warranted. You have to realize that when you're going up against the government, you better bring your A game. And when I say that, I'm talking about Dr. Akula. And Dr. Akula insisted upon representing himself pro se for so long, and went through several attorneys for so long, that by the time David DeVillers was called into this, I think he did a phenomenal job trying to get up to speed on all this in the very, very, very short, and when I say short, I mean about 3 months tops, amount of time that he had to do so. And so my point in that is that, look, if you're going up against the federal government, as you can tell, Dr. Akula had some $3.7 million at his disposal. And I assume by going pro se, he was doing his best to conserve some of those resources, but I'm not sure what good that accomplishes when in the end, if you lose, the government seized it all. So, look, my point is, go ahead and spend the money on a defense attorney from beginning to end, because it's tough enough to beat the government when they have all of the ammunition, and you're trying to fight this off, and you need a completely united front, and you need a strong legal individual or team. And I would hope that Dr. Akula would echo those sentiments. In conducting a little bit more post-mortem, I am totally baffled at this business of attacking a federal judge through a filing that was even made with the United States Supreme Court. And there were also attacks against lead prosecutor Catherine McHugh. It's just not smart. I mean, I don't know any other way to say it. And I'm not saying that Judge Afric let that influence him. He said he would not. I didn't even know anything about all this until, as I said, we did the semi-wrap, if you will, in our last feature. And I got shocked when Judge Afric said that, Dr. Akula, you have stated things about me which are false and without foundation, and also things about lead prosecutor McHugh which are false and without foundation. And he let him know that any such further, this was after he had been found guilty by the jury, any such further things along those lines is going to be viewed by this court as witness tampering. The next item of post-mortem that I'm going to cover, and then we'll pretty much be wrapping this up. There's a reason that attorneys do not want clients taking the stand in a criminal trial unless it's just absolutely hopeless. And this situation was far from hopeless. And look, you may remember that after Dr. Akula had taken the stand, and I did a little interview with Miss Belinda Parker Brown outside, and of course all of his friends and colleagues, they're saluting how great he did. But let me just point out two things. Cross-examination hasn't happened, that's number one. And I'm going to get to the most important thing in just a moment. But I've already covered in a prior feature those Medicare denials that were appealed, and every one of the appeals were denied. That was a really tough spot for Dr. Akula on the stand. I mean, he was like a deer in headlights. He tried to buy some time, but it was a disaster for him. And that wouldn't have been introduced had he not taken the stand. Secondly, while I was out with Miss Belinda Parker Brown, I had initially said that when the prosecution was hammering Dr. Akula about the low wages he was paying some of his employees, and Dr. Akula had said that, well, when you go into the bank, you don't pay the teller the same as the president of the bank. I own the company, for God's sakes. Well, in hindsight, I initially thought, hey, that was pretty sharp. But they were talking about Dr. Akula making millions. And so in hindsight, I think the jury may have very well perceived that response as being pompous and arrogant. I don't know that. I wasn't privy to the jury deliberations. But I think there's a possibility that that may have been the case. But here was the in my opinion, and I think I am on rock solid ground with this, the far more serious adverse fallout from Dr. Akula taking the stand. Now it's time for closing arguments, okay? And Catherine McHugh, who did the closing arguments, she's looking right at the jury, okay? So envision that you, in that camera, is the jury. This is what she said, verbatim, and I'm going to try to use reasonable voice inflection. Now remember, she is a lady, so it won't be as quite as authoritative as about what I'm about to do, but this is what she said. Dr. Akula is going to be sitting over to my left, okay? The jury, I'm looking right at the jury as she did. This is what she said. He is a liar. He has lied to his family. He has lied to this community, and he lied to you last week. Now I'm taking a long pause. And I literally got up and I had to walk out because I pretty well felt like, I don't know how you're going to overcome that, okay? You now have the full force and weight of a lead prosecutor looking straight at the jury and telling them he lied to you, okay? That is powerful, powerful, all right? Now, Mr. DeVillers did object, but the judge quickly told him that was a perfectly legitimate statement to make in close. Okay, and I think Mr. DeVillers knew that. I think he just wanted to at least create some little bit of damage control with the jury. But I can tell you David DeVillers was not happy when he saw that Shiva Akula wanted to take the stand, and you could see it all over his face when he stood from the table, and he said, "Your Honor, the defense calls Shiva Akula." So I know many times people may say, well, the guy needs to take the stand or she needs to take the stand. There are serious risk to taking the stand. And I just explained two of them for you. The cross-examination where he was deer in headlights on the, I believe it was 21 Medicare denials that had been appealed, and the appeals, the rulings were affirmed, the denials held. That tends to start to look like perhaps some fraud is going on. And that apparently, I'm not saying that influenced the jury, I think it probably did, and it would not have happened had he not taken the stand. But boy, those closing arguments with McHugh saying that he is looking straight at the jury, he is a liar. Now you imagine the impact of that, and there's nothing you can do about it. Nothing you can do about it. Nothing. So folks, that wraps it up for our coverage of the entire Shiva Akula matter. Let me just say this in wrapping up. If you are a physician out there and you are in any way being loose with these Medicare codes, tighten it up, because I've seen recently in the news where the feds have now charged a Lafayette area doctor with the same type of alleged fraud, and also I believe an Alexandria area doctor, and this is all in the last few months. So my advice is, if there's any doubt, get a professional. And look, I sat through there's no way I could understand those Medicare codes, all right, and I'm fairly intelligent. I mean, I didn't fall off a turnip truck, and I'm not condemning the jury, but there's no way they followed all that. I mean, no way. And I think that other factors, namely those effective arguments, he is a liar. I had said from the outset it's going to be opening arguments and closing arguments that are really going to weigh heavily. And I think closing arguments, I will tip my hat to Catherine McHugh. She did a phenomenal job, and I think a man is now spending 20 years in prison, as well as having been ordered to make a $42 million restitution. And as you've seen, the government has signed, the judge has signed the order, and that $3.7 million is gone, okay? It's now in the United States clerk's coffers, not Shiva Akula's. So don't be a tightwad if you have to defend this sort of thing. Bring everything you got, because you're gonna need it. And I think at this point, Shiva Akula is living proof. I am glad that I believe, well, I know our blog posts were able to assist in Mr. Porter's blog presentation, and I don't know, I don't think the right conclusion was reached here, but again, it doesn't matter what I think. It matters what the jury rendered, and they rendered their verdict, and we honor it, because that's the way our judicial system works. He got the trial, and he was found guilty. So folks, thank you so much for your dedication. That will wrap up the entire Sheba Akula matter. And we look forward to bringing you yet more coverage of, guess who? Louisiana State Police in coming days. Thank you so much for your dedication. We'll see you again soon.